welcome to the webinar. My name is Marty Schenkman, and we have a really important current program on the best vehicles for estate tax planning now. And we're going to also discuss and address how to draft and integrate some practical planning and drafting suggestions. The handout materials should be posted on the website, and you can access them. Our email addresses are on the last slide. If you have any issues, let us know. If you can't find the last slide, you can email me directly, schenkman@schenkmanlaw.com, and let me know whatever issue you have, and we'll address it. This program is being recorded because of a problem we had on a recent webinar due to internet issues and bandwidth that we couldn't control, and we apologize for that. And anyone listening that was on the prior recording, we assure you that we're going to try several different approaches to address that problem going forward. My first co-speaker is Teresa Bush from Interactive Legal, and I'm going to let her say a word on behalf of Interactive Legal, which is one of our sponsors. Teresa.
Thanks very much, Marty. As Marty said, I'm with Interactive Legal. I'm the Director of Education and Support Services there. And I want to thank Marty and Jonathan for giving us the opportunity to sponsor a program that is near and dear to us because it covers trusts that are in our program and that we work with every day. We'll be showing some of the provisions from the program here just as an idea for you. But again, we really appreciate the opportunity to kind of illustrate that planning still goes on and clients need to know about these techniques, especially now.
We're going to actually go even further than what Teresa said, and I'm grateful for Interactive permitting me to do so. Not only are we going to illustrate how a document generation software program can make you more efficient and make it easier for you to draft a lot of the sophisticated trust that we have. What we're going to also do is actually give you some of the sample language for some of the technical trusts like a SPAT and so on, right out of the Interactive system. So even if you prefer to use your own forms, which I don't recommend, we're going to give you sample language. Our second sponsor is Peak Trust, and Jonathan Blottmacher, another co-speaker, is going to say a few words on behalf of Peak. Jonathan?
Well, welcome everyone. This is, I hope, going to be a very interesting and timely topic. And I'm very pleased that Peak Trust Company, which has offices both in Alaska and Nevada, is a sponsor. My brother Douglas and my nephew Matthew are the principal people who run this, along with Brandon Santula. And I've used that trust company not just because it's a kind of a family thing, but because they do a great deal. I probably referred 200 clients to Peak Trust, perhaps when it was known as Alaska Trust Company, and not one of them has ever left. I really think they're very caring people, do a great job, and I'm proud that they're a sponsor. Marty, back to you.
I actually also use Interactive Legal for my drafting and my practice and my own personal trusts. Two of them, maybe more, are with Peak Trust, and I've worked with them. I set up a self-settled trust at Peak in 1998, I think within about 6 months of the first domestic asset protection trust statute coming out. And that's important not just in terms of a reference for a sponsor, but it's important to demonstrate that the planning Jonathan and I and Teresa are going to talk about in this approximately hour together, and I'm sure we'll go over, we always do, is not just something that you need to be talking to clients right now about. It's something that probably most of you should be thinking about for yourselves as well. And we'll discuss that. And I'm going to put Jonathan on the spot when we get there and ask him to tell you about some of the planning that he's done. I've made it a custom on every webinar to try to highlight, spotlight a charity. I just think it's a nice way to make a good cause out of the free education that we're trying to provide. On this program, the charity that we were highlighting is the American Brain Foundation. The American Brain Foundation is dedicated to brain research to cure brain disease. And I can say we because I'm actually on their national board. We firmly believe that as we start to unravel cures for any one brain disease, whether it's Alzheimer's, Parkinson's, multiple sclerosis, strokes, etc., the insights will help cure many other brain diseases. The ABF, the American Brain Foundation, has a unique tie-in, which gives it a unique ability to really identify cutting-edge research opportunities. They partner with and were formed and originally were part of the American Academy of Neurology. So they have the foremost neurologists in the country that help them identify research opportunities. Jane Ransom is the executive director. Her email information is there. Let's get started. So right now, we're in an incredibly difficult planning environment. Everybody's primary concern is health and safety, and we recognize that. But we also, as estate planners, need to guide our clients to take advantages of these opportunities. At the time that we're speaking, and who knows what will happen day to day, week to week, the stock market had dropped by more than 30%, down to about 18,500 from close to 29,000 approximately, and it's recovered probably half or more than half of those losses. So certainly, if everyone could have timed it ideally, we would have done our planning when the market was at 18.5. We don't know if it's going to go up or down. The gyrations and the movements have been phenomenal. That creates considerable fear and worries for clients, but it also presents significant opportunities. What we're going to do with Jonathan and Teresa's help is not only talk to you about planning techniques, but we're going to also talk to you about drafting and planning and document considerations and give you specific examples of how to draft the documents we're going to talk about. We'll use for just 3 of them the template from Interactive Legal to demonstrate to all of you the power of document generation software. If you still are using template forms for your practice, I strongly encourage you, especially if you're not a very, very large firm, to evaluate the incredible power of using a document generation system. I just think it's incomparable. And what I think may happen at the end of 2020, as we get closer to the election, many of our clients, and especially as we get more of the coronavirus issues under control, are going to realize that they need to plan and are going to become potentially more concerned about how the election may result in changes in Washington that may result in harsher estate tax rules. And even regardless of which party may control Washington after the election, the massive bailouts to address the economic issues that coronavirus has brought may well result in higher taxes. So we're going to talk about specific strategies for this unique environment and how you can use them and how you can apply them. On slide 9, and I'll give a quick run through, and then I'll have Jonathan and Teresa talk as we go through these. We're going to try to cover, to the extent we can, in this hour or so presentation, 7 specific techniques. We're going to try to keep it very, very practical. Spousal Lifetime Access Trust is listed first because for married clients, this is a great tool, and it may be the default plan for many married clients, and we'll talk about why for all of these in a moment. DAPS, Domestic Asset Protection Trust, or self-settled trust, for single clients that can't gain access through a spouse of an irrevocable trust. DAPS may be something they want to consider. Hybrid DAPS is really just a variant, and we're going to talk about a bunch of variations in DAPS that can be used to perhaps reduce the risk that some perceive with self-settled trust. And by the way, the various different variations, the techniques, the options for each of these is something that really demonstrates the power of document generation software. It makes it much more economical for you to draft and tailor planning, and we're going to talk about that. Item 4, the 4th technique is GRATS, and this is a great environment for GRATS with low interest rates and so on. SPLAT, Split Purchase Annuity Trusts, is a very creative concept that's an alternative to GRATS that Jonathan is going to explain. SPATS is, I guess, maybe the latest brainchild that Jonathan has had, a special power of appointment trust that solves and avoids the issues of self-settled trust that some have raised great concern about. And the last item, and I hope we have time to get to it and explain it, is another, I believe, creation of Jonathan, a split purchase trust that is another creative planning option. So we're going to get through all 7 of these and explain to you how you can use them. Very quick point on slide 10. It's going to be a hard sell to sell clients on estate tax planning today, but perhaps as the coronavirus fears and tragedies wane, which we all hope and pray they do, clients will start to reassess. But right now is an incredible planning opportunity. One of the things to stress to clients is that the planning is not merely to minimize estate tax, because that doesn't benefit them today, but rather it can provide incredible asset protection opportunities. And the second key point, and we're not going to address this in today's webinar because there's just too much material already, is that you can use non-grantor trusts to create income tax planning opportunities for clients. Jonathan, I just because it's so important to the introduction and to help estate planners encourage clients and get them to move forward, maybe you could just comment on the asset protection benefits of the planning and why in this current environment with economic downturn it's so important.
Well, it certainly is. I mean, we know that many businesses are failing. A friend of mine from another state contacted me the other day, and he had a very robust business, and now he's thinking about going into bankruptcy. Bankruptcy is an extreme thing to take in many cases, because not only will you lose a lot of your wealth and business opportunities, but the fact that you've gone through a bankruptcy may taint you for future ventures in the future. So protecting clients' assets so they don't have to go through bankruptcy, and protecting clients' assets so they do have resources, is exceptionally important. Let me mention that every one of the ideas that we're going to be presenting only works at the end of the day if it's not subject to claims of creditors, because it's the position of the Internal Revenue Service, which has been agreed to by the courts over the past 40 years, that if you make a transfer and it's subject to the claims of your creditors, it comes back into your estate when you die. So it's extremely important to make sure that whatever you do, it's not going to be subject to the claims of creditors, not just to protect the client, but protect the assets as well from the Internal Revenue Service down the line. Let me also mention something that everybody on the phone knows, but I'll mention it anyway. The real thing that makes either an income tax or an estate tax strategy work is the rate of return. You can do a perfect GRAT, which we'll get into. I mean, it is the most perfect GRAT. I mean, you just shake, it's so beautiful. But if the assets don't perform, it's been a waste of time. Again, the rate of return is the most critical factor in both income and estate tax planning. We have to keep that in mind. Right now, we have very low returns. That may continue, but we're going to talk about some things that maybe can be done. As Marty said, I wish we had time to go through some income tax planning, for example, using incomplete gift and non-grantor trusts. That really would be a great topic. And Marty, we've done it before, and I think we should do it again in the near future.
So if anyone is interested in non-grantor trust planning, if you email me, shankman@shankmanlaw.com, Jonathan and I did a series of 2 articles for Trust and Estates with Bill Lipkin, who's incredibly bright, on Ing trusts. And Jonathan and I did a couple of articles, I think also for Trust and Estates or Lineberg or both, on using non-grantor trusts for SALT deductions and so on. And I'll be happy to email those to you. One last quick comment, and again, I wish we had more time to address it, but in terms of asset protection planning, don't forget to protect yourself as the practitioner. Whether you're a financial advisor, attorney, accountant, insurance consultant, if a client is doing any significant transfers, especially to irrevocable trusts, consider getting a solvency affidavit signed by the client, even if it's not required because it's not a self-settled trust, even if state law doesn't require it for a self-settled trust, depending which state you're setting it up in. Have a balance sheet ideally prepared if the client will permit by the accountant for the client, so you have a real, true, correct balance sheet. Get financial forecasts by the wealth advisor. Make sure there's adequate life insurance in place. There's lots of things that we can all do, lien and judgment searches, to document that the transaction is not a fraudulent conveyance. And just keep in mind, it's not only important for the client to deflect a later challenge, and it's not just by the IRS, but by a claimant, but it's also important to protect you as a practitioner. The current planning environment, we've kind of already mentioned, so just very quickly on slide 11, Values are depressed. Stock market remains down. It's gyrating. We don't know if it'll be up, down, or sideways when you hear this program, but values are significantly down from where they were a short time ago. Interest rates are near or at historic lows, and I've given you some figures on slide 11. And with the massive federal bailout, regardless of what happens politically, I think it's pretty safe to assume they have to raise taxes on the wealthy, because these bailouts are going to have to be paid for. Now, it's going to be a balancing act, because obviously they don't want to raise taxes in a manner that's going to depress the economic incentives that they created to get business going up again. But higher taxes are pretty much, it would seem, inevitable. So that's the environment. That's why clients should plan. Low values, low interest rates, and things are likely to get worse. Tax rates are certainly not coming down. Now, the goals to address in planning, we've already mentioned asset protection planning. The last bullet point on slide 12, wealth tax is possible. We can't really help you plan for what we don't know what might or might not occur, but hey, it certainly seems plausible that if you shift assets out of the client's estate into irrevocable trust, that there may be a chance that those can escape a future wealth tax if one is in fact enacted. The key item really to all the planning, and is something we're going to stress through all of our discussions, is access. Clients, even very wealthy clients, many of them are very fearful. They've seen, even if it's bounced back, and maybe it's higher or lower by the time you hear this, but they've seen a loss of, at one point, more than 30% of their portfolios. Businesses, as Jonathan mentioned, are closing. The economic carnage, and that's really an apt word, has been horrific, and for many people, sadly, totally devastating. So clients are not going to take advantage of planning, in most cases, I would think, even wealthy clients, unless we can assure that they can get access to the assets they transfer. And I think it's very important to recognize that the tools we have, and that we're going to talk about in this program, are far more robust than in 2012. In 2012, as you all remember, there's a tidal wave of client planning near the end of the year. Lots of us did slats, but I think our knowledge and sophistication of how to tailor slats and other planning techniques to provide access is better today, significantly so, than it was in 2012. And a lot of the 2012 planning was followed up by buyer's remorse, where people were upset with the planning they did because they didn't have access. Many practitioners, in the rush to get planning done at the end of 2012, before we thought the exemption would drop from 5 million to 1 million in 2013. It didn't happen. But many of the plans that were done were focused on trust for children or grandchildren that provided no access to the client. In this environment, it's not only about possible tax changes, but more important, it's about economic discomfort, worry, and fear because of what's going on and still going on in the economy. So access is going to be critical, and Jonathan and I will talk about it. Slide 13, let me make a comment or two about document generation software. When we start to look at spousal lifetime access trust, so the variations that you need to create between each spousal lifetime access trust, and we're going to go through this, incredibly powerful to use document generation software to create the differences. And Teresa is going to demonstrate how. To do this on your own manually, if you have a firm form for an irrevocable trust, I think is not only dramatically more time consuming, but I think you potentially could introduce much more error than using software that can create these. The differences and variations, loan provisions, charitable provisions, and so on, and we're going to talk about these, I think will demonstrate the power of document generation software and how it's essential for your practice. And unless you're a very large firm, and I would think even in a very large firm, it would still be superior to have document generation software. But unless you have a large enough staff and cost structure to keep forms current and create the myriad of different variations, I don't know how you can draft efficiently and safely without document generation software. And we'll demonstrate why it's so flexible from a planning perspective as well. Final comment, 2 comments on slide 13. When I draft using document generation software, I do it very differently than a lot of our colleagues that I've spoken to that use different or various document generation software programs. Many of the colleagues that I've spoken to will give a memo or dictate something for an administrative staff member to use the document generation software to generate a document, and then give the attorney, and frankly, in a lot of cases, a hard copy document that they then mark up, or a Word document that they may mark up on computer. I do a very different approach. I actually collaborate with a colleague, and a senior level attorney that's been practicing for close to 30 years, and the two of us draft together. Now, we do that because when we decide which boxes to check or which form template to start with or how to structure the plan, we have a high-level discussion about what we're doing. And it's the opposite of having an administrative staff person do it, who I don't think could possibly understand the myriad of different variations and options that exist in a form. And the reason I do that is every time anybody drafts a document, if you collaborate with a partner in your firm, you're each going to have different perspectives on how to handle a different scenario. And if you have those discussions before you check a box, it's so easy to change what the ultimate document is. So what I find is we get a much more creative, much more tailored approach, and the changes made once we've generated the document are usually limited to just the tweaks that you have to make to conform a document generation software created document to the client's unique circumstances. And final point, in this coronavirus remote work environment, I use GoToMeeting, and there's, you could use Zoom, you could use WebEx, whatever software, and collaborate in the same fashion that I did when we were in office. So that's all of our introduction, and now we're going to dig into the meat of the program and start the first of our 7 forms. And again, we're going to try to focus very hard on being practical and give you some practical insights on how to use these. Jonathan, do you want to kick off a discussion of SLAT?
Sure. SLAT stands for a Spousal Lifetime Access Trust. And what happens is you create a trust for your spouse, and perhaps your spouse will create a trust for you. You have to worry both for creditor purposes, where the doctrine of reciprocal trust arose, and for tax purposes, that you don't fall under that doctrine. Again, if you fall under the doctrine for state law creditor purposes, it's not going to work for estate tax purposes. And what happens is the trust that the one spouse created for the other is redone. So if a wife creates a trust for her husband and he creates one for his spouse, both for creditors' rights and for tax purposes, and this has been applied for estate, gift, and income tax purposes, they'll go ahead and they'll say, well, actually, the trust that the wife created for her husband, we will treat as though he created it for himself. And the reverse, the trust that the husband created for the wife will be treated as though she created it for herself. So you have to avoid those doctrines. And what you're going to have to do is to make sure they're sufficiently different. And some of the ideas that we like are create the trust at different times. My wife and I created SLATs for each other back in 2011 as we anticipated the exemption was going to drop back to $1 million. Unfortunately, unlike Marty and his wife and Teresa and her husband, we couldn't afford to put $5 million into trust for each other, but we did some to try to preserve some part of the $5 million exemption. Of course, that turned out, as Marty said, to not be true, and we had buyer's remorse when people came back and said, hey, I did this, now I don't have access to the money, and I wish I hadn't done it because the exemption has stayed at $5 million, and then all of a sudden it went up to where we have it now, over $10 million for each spouse. But you want to have them created at different times. When my wife and I did them, we did them 7 months apart. We funded them with entirely different assets. The trust for my wife was some of our real estate, and a little bit of cash, bonds primarily. And the one that my wife created for me was entirely marketable securities. Also, we had entirely different trustees and very, very different terms. For example, I gave my wife the ability to get anything she wanted under a so-called HEM standard. She had the right to take property out for her health, education, maintenance, and support. And that wasn't a problem either under Alaska, which is the law I used to create the trust, or under New York law, because there is an exception from creditors' claims if you allow distributions by the beneficiary only for health, education, maintenance, and support. And so we had that there, and it was just a very good thing to do. We also had different trustees, and I gave my wife, and this is a very important thing to think about, a presently exercisable special power of appointment. I did that on account of a case called Levy, which was decided by the tax court in 1986, where Mr. and Mrs. Levy created identical trusts for each other with identical assets using the same lawyers, same governing law. Everything was the same, except that Mr. Levy gave Mrs. Levy a presently exercisable special power of appointment. The IRS conceded, and the court found that having that power in her trust, but there wasn't a comparable power in the trust she created for her husband, meant that the reciprocal trust doctrine, at least for tax purposes, could not apply. I don't want to rely on that alone. I want to have, it's one case by the tax court. I want a lot of differences, and that's what we do. Marty, what about using different state laws?
One of the things that I like to do for client slats, and I've actually done for the slats that my wife and I created in 2012. And I want to reiterate a point that I made early in the program. Jonathan and I have shared that we've each created slats for ourselves and our spouses. It's not just about estate tax. All of us as practitioners face really growing liability because of the environment that we're in. And I've done some webinars on that, and you'll see them on the Shankland Law website under webinars. There are some really rough cases out there. We want to protect our assets as well, and I encourage you to do it. So my slat for my wife, Patty, has been structured in Alaska, and my wife's Patty's slat for me and all descendants has been structured in Nevada. And if you do not have the wherewithal to draft for all these different states, and there's now 19 DAP jurisdictions, and I would recommend, and I'm sure Jonathan agrees, that you try to put your slats in a DAP jurisdiction. It just gives you a fallback position if it's challenged. All you have to do is just check a different box for which state law you want to govern the document, and the document generation software will infuse many of the provisions you need under that state's law. Now, keep in mind, you still want to have local counsel review the trust for local law if you're not admitted in that jurisdiction. So in Alaska, I had Abigail O'Connor review that trust, and in Nevada, I had Kristen Simmons, who works with the Oceans, review that trust, and in each case, give me an opinion of counsel, and I do the same thing for clients. But again, that's the power of document generation software.
Marty, Marty, I want to emphasize what you said, which is so important. Although in theory, if you avoid the doctrines, you're not going to have a state tax inclusion. So even if they come out and say that the trust that Marty created for Patty, we're going to treat it as though Patty created it for herself. Even if that happens, so you're worried about, creditor protection being lost and therefore state tax inclusion, and you didn't effectively use your exemption. That's why it's so important to be in a state where even if they say, okay, Patty, you went ahead and created this trust, which nominally Marty created, but if you're in a DAP jurisdiction, you still should win, provided you can establish that you weren't doing it to defraud a creditor. And one of the things, and this is so fantastic right now, right after the Alaska Trust Act, which I wrote, passed in 1997, I was invited to appear before the annual meeting of the bankruptcy judges of the United States. All bankruptcy judges are U.S. judges, and they invited me because they wanted to find out about it. And I told them that the reason I drafted that and lobbied so hard to get it through wasn't so people could use the law to bill creditors. Indeed, the statute says, as all states do, this doesn't work if you're trying to defraud a creditor. But I said I was doing it because my clients, which is what we're talking about right now, are fearful for giving up wealth. And if I could have them transfer assets to a trust and keep it out of their estate, but allow them at least indirectly some access to the property, they would be much more prone to do it. Every judge who was there, they didn't all speak, but all the ones that did said, if you could establish you were doing this for estate tax purposes and not to try to defraud a creditor, we are not going to come back and pull those assets back into the estate. And indeed, there's a federal law now, Section 548E of the Bankruptcy Code, which pulls back assets transferred to a self-settled trust, one you create or settle for yourself, if you go bankrupt within 10 years, but only if the creditors can prove, or the trustee in bankruptcy can prove, that you created that trust in order to hinder, delay, or defraud creditors. When you can establish that this is being done for estate tax planning reasons, and it has to be because the exemptions are going away at least in 2026, and Marty and I believe, and I know many of you also believe, that we're probably going to reduce exemptions and increase estate tax rates in the relatively near future to pay for the cost of the coronavirus.
One of the issues that we discussed early on is that it's critical to preserve access. So the reason we started our presentation with Spousal Lifetime Access Trust with Flats, it's a married couple comes to you as clients, and we'll talk more about self-settled trusts for single clients. But for a married couple, if I have a trust for my wife has a trust for me, I'm a beneficiary of her trust, she's a beneficiary of my trust, and we theoretically, with the approval of each independent trustee, can get a access to all the assets in the trust. But you can go further to provide other ways to indirectly, if you will, or provide benefit to the client. So if a client's coming and they're concerned about losing control, it's nice to say, well, you're a beneficiary of your spouse's trust, your spouse is a beneficiary of your trust. What if the spouse dies prematurely? Well, life insurance is something that should always be discussed, or certainly should be discussed when appropriate, because that's a great way to supplement what happens if a particular client can't access their own trust because their spouse died prematurely. But there's other ways we can also address access. On slide 17, you can appoint somebody in a non-fiduciary capacity to make a loan. If the client needs funds and can get a loan of money or assets in the trust, even if they have to pay interest, which they should, they still have access to money, and that's very important. So loan provision, which traditionally, historically, we used for many years to create or bolster or backstop grantor trust status, perhaps in conjunction with a swap power, can be used affirmatively, not just for grantor trust status, but rather to provide another means of access. Now, in terms of charity, there's a number of different ways discussed on slide 17 that you can have funds in a trust used to benefit charity. Now, you cannot have the grantor's flat pay a pledge the grantor made, because it's now being used to discharge the liability of the grantor, and you may have destroyed the trust. But what you can do is, if the client has charitable intent and the trust makes charitable contributions, that indirectly may benefit the client. On slide 18, a vacation home could be used.
Marty, I'd like to go. Marty, I'd like to go back to the loan to the grantor. One of the problems with having a domestic asset protection trust, if you've made it a completed gift, which you have to use your gift tax exemption and keep it out of the estate, as you give money to the grantor, assuming the grantor is a beneficiary, you now are taking assets that were estate tax free and putting them into the estate taxable range. Even if the grantor expends them, there are other assets that otherwise would have been expended. By loaning to the grantor, assuming it's a bona fide loan, you can go ahead and not take away the estate tax benefit of the trust, because you're not actually transferring property to the grantor, just loaning it. So that's something to consider, especially if the grantor comes into the trustee and says, look, I need $5 million to keep my business going. Make a distribution to me for that. Well, there are a lot of options, but one of the options that should be considered is making a bona fide loan to the grantor. That way, when the grantor later dies, her estate will owe that $5 million, and it will actually be deductible for estate tax purposes, so you haven't depleted the trust. So this is a key element to have it in there. You don't have to say for the grantor alone, you just give the trustee the power to make loans, including to beneficiaries, on such terms as the trustee determines is appropriate. But again, you want to make sure that you require adequate security for any loan to the grantor?
On slide 18, the trust can own personal use assets. I've just illustrated a vacation home. And if the trust owns personal use assets, it's another way that the clients can indirectly or directly really benefit from the assets. And the final point on slide 18, I know many of us have often included, but perhaps not always, tax reimbursement clauses. Years ago, it was not as assured that practitioners included it, certainly in 2012, and there's some cases out there where people are challenging what was done. But why not include a tax reimbursement clause so long as you're in a state where that doesn't cause a state inclusion? And I don't believe any of the DAP jurisdictions would cause a state inclusion for a tax reimbursement clause. So that's another way to provide benefit. So just to sum up, we've talked about life insurance, personal use assets, income tax reimbursements, paying charity, loan provisions, plus the spouse as a beneficiary. Those together are a very substantial number of provisions that can be used, and they can be mixed and matched between the two trusts to create further differences between each spouse's slat. Now, combine all those options along with, or variables, along with all the different things Jonathan talked about to make slats different, from different crummy powers, different powers of appointment, testamentary, lifetime powers, and so on. You have a lot of different variables. All of that plays into the power of document generation. So, Vanessa, why don't you show on these next slides and explain how powerful a document generation software program can be to deal with these multitude of variables?
Absolutely. Yeah, what we're seeing here is the menu that comes up when you're choosing to draft an irrevocable trust in our system. And you can see highlighted there at the bottom in the red box, there are two versions of the document that are specifically called spousal non-reciprocal gifting trusts. And there's one labeled spouse 1 and one labeled spouse 2. And those were created specifically to give the drafting attorney two options that are dramatically different. They have different powers, or different beneficial interests in the hands of each spouse. Again, like Marty and Jonathan were both mentioning, different powers of appointment perhaps, different crummy powers, different rights that each spouse has in the other spouse's trust. And if you start there, you can be assured that you have two trusts that are dramatically different. And we also have a drafting guide that kind of will walk the drafting attorney through that if they want that background as well. But that gives you those markedly different trusts from the get-go. And then as you get into selecting options, you'll see on the next screen, you have a lot of different provisions that you can add. You can choose different distribution provisions and standards. The option highlighted here is actually a contingent provision you can put in to allow property to be included in the surviving spouse's estate if it turns out that that would be a good thing to happen down the road. Say there isn't a reason to keep it out for estate tax purposes because the exemption surprisingly remains very high, but the property has a low basis and we want to step up in basis. So this is an option to bring property back into the estate if that turns out to be a good idea. So it's just, a flexibility option that you can add. The next screen has another flexible option that we refer to as a floating spouse provision. And I think this is something that Jonathan actually came up with at one point, where you can define the spouse to be the current spouse only, or it could be the person to whom the grantor is married at any time. And so the trust could stay in existence for a future spouse if that happens to be the case. And then another flexibility option on the next page, I think, is where we're showing the different grantor trust options, right? You've got several different ways to create grantor trust status, and if you choose, for example, to use a power of substitution, you can be assured that the required safe harbor language is in there to prevent inclusion of that in the grantor's estate, even if the grantor holds that power. So that shows you quite a few options for drafting a slat where you can pick and choose on the screen and have that flexibility, but yet start with trust that will not be reciprocal. And we'll come back and look at options and some of the other strategies that we're going to talk about as we go forward.
So when I draft non-reciprocal slats for clients, what I do is, let's say the client may only want to commit to one trust today, and they're not sure whether the spouse should do one. I have the client authorize me to prepare both non-reciprocal slats today, because if you're choosing option one, option two, and you're going through the multitude of different variables that we've talked about, and there's lots more in the software, I'd like to draft both of them at the same time, so it's fresh in my mind right then and there. When I draft one spouse's trust, I then immediately, as soon as I finish, draft the second spouse's trust, and it takes 30 to 60 minutes maximum. I know Jonathan will say you can do it in 15 minutes, but his fingers type faster than mine. But for an extra 30 to 60 minutes of legal time, I have another trust generated, and I save the trust with the word hold, not to review, so we don't do anything with it. So if the client hasn't committed to doing both trusts right now, but just one, and we're going to show you why they may do that in a minute, which is important to the current planning environment, I know I'm not going to mix up or have to go back and rethink or review the first trust to figure out how to draft the second. Very, very efficient for the client. And the other thing, in terms of drafting, you may want to have the second trust drafted and intentionally, as Jonathan said, not even review it, because now the date stamps on the documents, the drafts in my computer show that we didn't even review it or update it or try to finalize it for many months after the first spouse's trust was done to confirm the dating. Now on slide 23, this is the language out of Interactive Legal. This is one of the provisions right from the trust document to show you how you provide for the grantor. In this case, they call it wife instead of spouse. But this is the provision that creates the slat. And on slide 24 is an additional illustration of a power of appointment that can be used to differentiate this trust, because you would have a different one in the other spouse's trust. So that sample language may be of help. But hopefully what Teresa did demonstrates the incredible power of using document generation software. The templates are pre-populated, so if you want to differentiate the trust, I would always add to this, in most, not all cases, but when the client would permit, 2 different DAP jurisdictions for each trust to differentiate the trustee and the state law, which I think adds even further to it, plus all the things Teresa talked about. Now, on the next few slides, go on.
I was just going to say one thing that I think a good document generation software is always going to give the drafting attorney complete control over what's in the document. So there's nothing forced upon you. And so we give you these 2 dramatically different trusts, but as Marty noted, you can go through and change options. And so you're always in control and can make the trusts more different if you want them to be, and you have to guard against not going through and making them more similar. So you're always in complete control, which I think is an important point as well.
Absolutely. Thank you, Teresa. And that's why I try to draft both at the same time whenever possible. Slide 25, 26, and 27 is a checklist from an article I did many years ago with Bruce Steiner on how to differentiate trust. And I thought that checklist would be helpful, and you can use it whether you're drafting using your own forms or a document generation program. We're not going to go through it to belabor it, but I thought that would be helpful. It keeps going on. So there's 6 pages of differences you can use to build in. On slide 31 and 32, I just want to generally say, because I don't want to belabor it, but for a lot of clients with a moderate wealth, moderate relative to the current very high exemptions, it may be better not to do non-reciprocal slats. It may be better in terms of safeguarding the exemption for one spouse only to make gifts. And you should go through the example on slide 31 and 32, because if a client's worth $20 million and the most they're going to give away, or in this case $16 million, and the most they're going to give away is $8 million, they're going to preserve more exemption if the exemption declines, as Jonathan said, he and I both think is likely given the bailouts and the current environment. It would be better for one spouse perhaps to give an $8 million gift if that's the total they're comfortable giving, so you fully preserve the other spouse's gift. If the exemption amounts are taken back, which is what was in the Sanders and Gomez proposals in the Senate and House respectively, to 3.5 million, which was the figure in 2009 that President Obama had also proposed year after year in his green books. This example will demonstrate why you're better off with just one spouse making gifts. If you have only one spouse making a gift and you vary from the non-reciprocal trust structure that we've described, you've got to make sure to deal with the risk of premature death if the settlor grantor spouse survives and the other spouse dies, because then they lose the indirect access to the other spouse to the trust. And in those instances, you may want to either use a SPAT or one of the other techniques, or a self-settled trust or a hybrid DAPT, or make the SLAT really a hybrid DAPT. And we're going to go into these other techniques. So, Jonathan.
Marty, Marty, let me say one more thing about non-reciprocal SLATs under the reciprocal trust doctrine. If you have a client who is not married but is got a close relative, say you have a sister who's very close with her brother, or two sisters who are close, and they have adequate wealth, that using their exemptions now would make sense for a variety of reasons. Sisters, brothers, even cousins can do non-reciprocal trust for each other. In fact, the first reported tax case involving reciprocal trust was for two Lehman brothers. The Lehman Brother firm, their lawyers went in and said, each of you should create a trust for each other. Well, they were identical, same date, same assets, and the tax court and then the Second Circuit said, doesn't work. It's going to be in the estate of the beneficiary of the trust, because he was treated as though he had created the trust for himself, and there was no DAPT jurisdiction in those years, and as a consequence, it didn't work. But again, you can use SLATs for two spouses, but you could use non-reciprocal beneficial trust for two brothers or two other people. So that's something else to keep in mind.
So let's change gears and go on to the second technique we wanted to talk about, domestic asset protection trust or self-settled trust. Now, there's lots of naysayers that say if you don't live in a DAPT jurisdiction, these trusts don't work. But we now have 19 jurisdictions, Connecticut and Illinois, I think were the most recent two. It started and Jonathan, correct me if I'm wrong, I think Alaska, I know Alaska was the first, I think it was in 97 or 98 that Alaska created its statute. And it's now grown to 19 jurisdictions. So you can hardly say that this is a one-off situation with 19 states. And it presents a fabulous planning opportunity subject to some risks. Jonathan, do you want to, on slide 34, give a sort of a quick thumbnail of some of the history of DAPT and some of the issues that the naysayers put forth?
Well, up until 1987, when Alaska passed its Trust Act that year, every jurisdiction in the United States, it appears, said if you create a trust for your own self, it's a self-settled trust, even though you're a discretionary beneficiary, and even though you're not trying to bilk a creditor. It's just that, you want access, or it makes sense, or you chose to make yourself an eligible beneficiary only because you wanted to make sure it was a grantor trust. Whatever the reason was, throughout the United States, that trust was permanently subjected to the claims of your creditors. So you create a trust in 1950, you're in a car accident in 1985, well, you're sued, there's a judgment against you. The plaintiff can go to the trustee of that 1950 trust and say, give me all the money. And there was no choice, it had to be done. But the law began to change. I mean, a typical one is still in New York, EPTL 7-3.1, a disposition in trust for the use of the creator is void is against existing and subsequent creditors of the creator. Self-settled trusts are just permanently subjected. It's just a rule. Now, of course, New York and every other state that has this has exceptions, for example, for IRAs, which are trusts. And in most states, it's unlimited. And some, like California and I think Indiana, there's a limit, but that's it. After the Alaska Trust Act passed, the bankers got together, and as part of the United States Bankruptcy Code revisions, they got enacted Section 548E of the code. And that basically says that if you create a self-settled trust or, quote, similar device, close quote, whatever that happens to be, it will be brought back into the bankrupt estate to be distributed to the creditors if it was created within 10 years of the filing of the bankruptcy, but only if the creditor or the trustee in bankruptcy can prove you created it to hinder, delay, or defraud creditors. So again, if you can demonstrate you were just trying to do good estate planning, I think you're absolutely golden. I think you've got an absolutely complete reason to do this. And a lot of people have said, they don't work. But again, you're going to at least defeat 548E. But you want to make sure you're in a jurisdiction where you do get asset protection, one of the 19 states that now provide asset protection for a self-settled trust. And again, I don't think it's so important. Some people say, well, Ohio only has a 2-year term for fraudulent transfers, and some states have 4, and I'm going to go to the state that has the shortest. Why do you care if you're not doing it to hinder, delay, or defraud a creditor? In fact, if you're in a state that only has a 2-year statute of limitations for transfers, it's not going to do you any good if you were trying to hinder, delay, or defraud creditors, because even after the 2-year window expires, you're going to be thrown into bankruptcy and you're going to have to cope with 548E. So if you're doing it for estate planning, I don't think you have to look around for that jurisdiction, which has the shortest statute of limitations for a fraudulent transfer. You weren't trying to hinder, delay, or defraud a creditor. You were trying to do estate planning as the window on using the exemptions is being drawn tight.
So I don't think anybody questions that if you are in a DAP jurisdiction, one of the 19 states, that a self-settled trust should work. The question, as Jonathan illustrated using New York, is if you live in a non-DAP jurisdiction, California, New York as examples, or Florida, would a self-settled trust work? There's also the belief, and Jonathan, since it was your PLR, you should comment on the bottom of 35, that if you set up a self-settled trust and it works because your creditors can't get at it, those assets should also be excluded from your estate. Do you want to comment on the PLR?
Yeah, after the Alaska Trust Act passed, we tried to get a ruling from the IRS, and the IRS basically wouldn't rule. They said it's just too good a deal for people to be able to create trusts of which they're beneficiaries and keep them out of their estate. So yeah, we know it works, but we're not going to rule. But then they came out with Revenue Ruling 2004-64. That ruling is known really for the proposition that a grantor doesn't make a gift by paying income tax on income imputed to her under the grantor trust rules. The IRS had issued a private letter ruling in 1994 saying that would be a gift. So you have a grantor trust, you're required by law to report that on your tax return and for you to pay the tax. But the IRS took the position, because I went around the country saying the opposite, that it would not be a gift when you pay the income tax and you'd be able to further deplete your estate without making a gift. So the IRS was very unhappy about that. In fact, it used to require people to put certain things when they asked for a ruling and you had a grantor trust. But in 2004-64, 10 years later, they finally came out and said, okay, if you're paying income tax, which the Congress says you have to pay because the congressional rules under the grantor trust system says you have to report it and pay the tax on it, that's not a gift. But there's another very important aspect to 2004-64, which is that if you have a tax reimbursement clause, then the trust is going to be includable in your estate if, but only if, creditors under applicable law can attach the assets in the trust. So if you create the trust in a state where creditors can't attach it, it seemed absolutely certain it would not be in the estate. In fact, when we asked for the private letter ruling, which we got in 2009-44002, when we initially put it in, they said, hey, this is a comfort ruling. It's so clear under 2004-64 that it's not includable as long as creditors can't get it. So that's where it stands. One of the things to keep in mind, if you put in a tax reimbursement clause, and that doesn't under governing law cause creditors to have access automatically, as it won't in all, I think, of the DAP jurisdictions and a number of other states as well. Even New York now has a rule that says tax reimbursement clauses don't allow creditors access to it. The IRS went on further and said, if we see a pattern that every time, the grantor has an income tax problem, the trustee gives the money, then we're going to say that the trust is includable in her estate under Section 2036A1 because there was an implied understanding it would be done. And in fact, maybe what you want is to allow someone other than the trustee to be able to reimburse the grantor. You give somebody a special power of appointment, and don't tell them they have that power of appointment until quite a while after the trust is created. If you can demonstrate that this person didn't know of her power to reimburse the grantor until after the trust was created, I think it completely foils any argument the IRS might make that there was an implied understanding.
So what are some of the things that we want to take a look at on slide 36 in terms of planning and drafting? And again, the key point is that if you set up ADAPT and ADAPT jurisdiction, and we're going to talk about options that may be safer later, many practitioners and commentators do believe that if it's done properly and it's not a fraudulent conveyance, unlike the Wacker case and the Mortensen case and the Huber case, which all had really significant issues, that the DAP should work. Some of the things you can do ahead of time, and we talked about these briefly before, you can have lien and judgment searches done on the transferor. We actually, in my practice, use an independent forensic department at a large accounting firm to do the searches because I think it just seems more credible than our doing something. We have a balance sheet prepared and signed by the client showing significant net worth. We always recommend that the clients have their wealth advisor, financial planner, create some financial forecasts and modeling to show that they don't need the funds being transferred to the trust to live on. Even if state law doesn't require it, we always have a solvency affidavit signed. Another option, third bullet point, is consider the client, if they're very concerned and they live adjacent to a DAP jurisdiction, change their domicile. I've only seen one person take that planning step, but you know, if somebody really wants to protect the DAP that they have and retain access, and if they're very concerned about lawsuits in the current environment because of the recession that seems like it is going to happen, they can move. There's now 19 different states, and if you take a look geographically, there's a swath of states across much of the middle of the country that permit self-settled trusts, so that is now a viable option. Another thing that could be done, which is on the fourth bullet point, and this again highlights the next several of these, the drafting software benefits of this, you could defer any distributions for 10 years and 1 day to avoid the ability under 548E of the bankruptcy code for the bankruptcy trustee to disavow the transfer to a self-settled trust. You could prohibit distributions if the grantor is married. And why would you do that? Because the spouse can be a beneficiary without creating a self-settled trust status. I've seen some practitioners include a net worth requirement. No distributions can be made to the settlor unless the settlor's net worth is demonstrated to be under $1 million. I haven't used that technique, but I've seen that added as well. You might want to, as a safety feature, and this is almost the flip side of the hybrid DAP we're going to talk about, give somebody in a non-fiduciary capacity the power to remove the grantor as a beneficiary if that becomes advisable. And again, the more variance you have, the more powerful and efficient document generation software can make this. So let's go back to Teresa, and perhaps you can walk us through some of the drafting options in Interactive Legal and show how document generation software can help make all these selections.
Yeah, absolutely. And this goes back to some of the points you were making just on the prior slide. Here in the red box, you have options for limiting when the grantor can get distributions. And if you want to limit to the 10-year period that you just mentioned, you know, there's an option for that. That's not the one that we have checked. We have checked the one here that says only after 1 year. But if you want to limit it to 10 years and a day, you can do that. If you want to use a custom period, maybe the client just says, you know, I'm going to put this in a way and I don't need to touch it for 15 years. You could put a custom period in as well. And that gives you, you know, the ability to tailor it on the fly, and you don't have to draft a new provision. All of the different options are already built in. On the next screen, there's a menu of different choices for who the beneficiaries will be of the trust during the grantor's lifetime. So if you want to include just the grantor and the grantor's spouse, or if you also want the kids to be beneficiaries and able to receive distributions. You have a lot of options on setting up who can receive distributions from the trust while the grantor is living. The next screen has a couple of those other options that you just mentioned as well, Marty. You can say that the grantor, and this is the first box that's checked there in the highlighted area, the grantor is eligible to receive distributions only when he's not married, because if the spouse is a beneficiary and the grantor is married, well, distributions can be made to the spouse, and then the grantor will benefit tangentially from those distributions, for example. So you could limit it to only if the grantor is not married at that point. Also, the ability to take the grantor out as a beneficiary, giving somebody that power, and it could be, as here we've given it to somebody who we will call a trust protector, and we'll name them, and we could name a successor protector as well, and the protector can have certain powers, one of which is removing the grantor as the beneficiary, or you give that power to somebody else, but a lot of people like using the idea of a trust protector. I think the next screen has a couple of examples. The one on the bottom is a reversionary disclaimer option that we have in some of our trusts. And this is a little bit of an escape hatch that was, I think, crafted back when we were all doing that planning in 2012, where if you had the buyer's remorse within 9 months and realized we didn't really need to do this, you had a way to have someone disclaim and essentially undo the planning. It shows up in some of our trusts, and I just highlighted it here as an example, again, of something that you wouldn't have just in your typical form book, but it's there built in when you're having a menu of a lot of options. And then at the top, I just wanted to highlight that there are boxes here that you could check if there's, pending court action or any pending administrative proceeding. And the idea there is many states are going to have a requirement that you fill out an affidavit saying, here are all the circumstances that are relevant to this trust as far as any pending lawsuits and such. And with the document generation system, you're going to get the right affidavit, the right language in the trust that's necessary for the particular jurisdiction. Of course, you still want to have it reviewed by local counsel, as both of you were suggesting, but you're starting from a point where the document should comply with that local law, and you don't have to start from scratch complying with those local domestic asset protection trust statutes.
Thank you, Teresa. I think...
Yeah.
Oh, go on.
I was just going to say, I know you have some sample language here, and these also are provisions that come from the interactive legal documents. I think the one here is talking about the grantor being a beneficiary, unless in that final bullet point he's married, and also this is the one that says 1 year after, but it could be 10 years after if you pick that option instead. Right.
So slide 41 is the actual language from the interactive drafting system to do exactly what Teresa described. And I think that the descriptions that Teresa gave demonstrate that I don't know how a practitioner, even in a fairly large firm, could have the ability, if you're using just a form data bank, how you could possibly craft forms to address the myriad of different options. There's 19 different states. We've gone through probably 6, 8, 10 different variables that you may pick. I don't know how it's practical to do that and tailor a document cost effectively from forms. The other item on slide 42 is the power to eliminate the grantor, and we've illustrated that as well. So, Jonathan, one of the concerns that some people have, there's always naysayers. There's the Renson case in Florida that ignored a Belize trust and applied Florida law. It was also a bankruptcy case. There are those that are concerned that if you do not live in a DAP jurisdiction, New York and California, Florida, and you set up a DAP in Alaska, Nevada, South Dakota, Ohio, Connecticut, wherever, that's not going to be respected. So one of the approaches that has been suggested is what some have called a hybrid DAP, which is really to not include the beneficiary, the grantor as a beneficiary initially. You want to comment on that?
Yeah, I mean, this is an idea that since the grantor is not a beneficiary, it's not a self-settled trust. But then you allow someone to go ahead and add the grantor in. So if trouble arises, you're protected because it's not a self-settled trust. And you're in Florida, you're in New York, you're in California. However, there is this case called Iannotti, which is from the state of New York. It involved social services. But the court said that they would treat the grantor as a beneficiary, so it was an available resource and social services could attach it because someone could add the grantor in as a beneficiary. Now, in that case, the person, which was a trust protector, happened to be acting under a fiduciary duty. So if you want to go ahead and have the ability to add the grantor in as a beneficiary, I would urge you to make sure that it's not in a fiduciary capacity. Now, Alexander Beauvais, who's a very great lawyer from Boston, in fact, got a PhD on writing his thesis on trust protectors, believes that trust protectors are always acting under a fiduciary duty. Well, Alexander and our wives went to dinner one night, and he, I think, conceded to me that because under Alaska law, a trust protector is never a fiduciary unless the instrument says otherwise. So if you're in Alaska, where you start with you're not a fiduciary, and if the instrument says you're not a fiduciary, maybe you're okay. But in any event, regardless of what you want to do, because of this Iannotti case, make sure that the person who can add the grantor back in or add the grantor in as a beneficiary is not acting under a fiduciary duty. In addition, I would suggest don't make it a beneficiary, because the IRS's position, which I don't think would be very likely to cause a serious tax problem if it's a purely discretionary trust, but it's the IRS position that if you're a beneficiary and you add someone else as a beneficiary, you have now made a gift because what you may get could possibly be reduced. So you want someone who's not a fiduciary, not acting under a fiduciary under a fiduciary duty to be able to add the grantor back if you want to have the grantor to be able to be added back at a later time.
So on slide 45, one of the things that could be done to make it even safer, so if a client sets up a spousal lifetime access trust, and because it's not feasible to buy life insurance on the beneficiary spouse, the settlor spouse is concerned that if the beneficiary spouse dies prematurely, they can't get access to the money, and insurance, again, is not viable. And maybe the loan provision and the charitable provision and the tax reimbursement provision and so on are just not enough to get the client comfortable. You could add a hybrid DAP provision to the spousal lifetime access trust. Just make sure you put the trust into one of the 19 DAP jurisdictions. But if you want to even be safer than that, on the bottom of 45, common language in many trusts permits the trustee to divide the trust. So before you have the non-fiduciary exercise a power to add the grantor back as the beneficiary, have the trustee first divide the trust. If it's a $10 million trust and the grantor has need for some funds, maybe the trustee first uses some of the general provisions in the trust to divide the trust into two separate trusts, one with $9 million, one with $1 million. Thereafter, the person in the non-fiduciary capacity exercises the power to add the settlor back as a beneficiary to the $1 million trust. Seems that it would be very difficult for a creditor or claimant of the IRS to argue that somehow the $9 million separate trust, which was separated before the exercise of this power, is somehow reachable or includable in the estate. So a hybrid DAP can be integrated into a SLAT or done as its own freestanding trust and can provide a great way to get access, which is critical for our clients in the current environment. Let's change gears and talk about GRATs. And I think most practitioners on the call are familiar with GRATs, so I'm going to let Jonathan give a quick introduction, but what I then want to do is emphasize why the current environment is different. It is different, and the standard way that we've traditionally done GRATs may not be the optimal approach in the current environment. But Jonathan, you want to lay the foundation first on GRATs?
Sure. This all comes about because of Section 2702, which was enacted in October of 1990, which basically says if you make a transfer in trust and you retain an interest in the trust and the remainder is going to go to or for members of your family, then the value of what you've retained is going to be zero. So they did make a special rule where you retain an annuity. It's not an exception to 2702, but it's a special rule. And that led to the development of so-called GRATs, Grantor Retained Annuity Trust, where you retain the right to an annuity. And I don't like to make the value of the annuity absorb 100% of the assets, which is what some people call a zeroed out GRAT, but you can make it pretty low, and you can get this language from the BNA tax management portfolio that I do with Diana Zadel and Georgiana Slade under section 2702. It's BNA tax management portfolio. Actually, it's Bloomberg now, 836 second. It's in the process of being revised. And GRATs work great if you have growth, because basically what it says is you're going to get back the full value of what you put in, plus the so-called Section 7520 rate at the time it was created. Right now, the Section 2520 rate is 1.2%. So if you put in $1 million, and we don't know if you can really do a one-year GRAT, but just for purposes of illustration, you say, I want to get back $1,012,000 at the end of the year. Well, that would mean, because the IRS is assuming that you're only going to earn 1.2%, which would be $12,000, that you're going to get back everything. I wouldn't go that far. I'd go a little bit less. Maybe, the million plus 11,000 or something. In fact, you can use a formula, and Georgiana and Diana and I discussed that in detail and have formulas to try to protect yourself. But the problem with GRATs is not only do you have to beat the Section 7520 rate, but you can't leverage your GST exemption. And if the grantor dies while she's entitled to the annuity, there is going to be some part of that trust which is going to be includable back in her estate. We'll talk about that in a minute or two. The typical structure which has been used are short-term rolling GRATs, where you do, say, a 2-year GRAT, and you provide maybe automatically that any annuity that comes back to the grantor, unless the grantor takes it as she's permitted to, it will roll into an identical new GRAT. That way, anything that comes out, whether that GRAT has been successful because you've beaten the Section 7520 rate or not, you get it back and you can re-roll it. And over time, you're going to be able, if the markets increase or income increases at some time, you're going to be able to do it. Understanding when you re-GRAT it, there will be a different Section 7520 rate in most cases. And again, you use a formula to determine what it is. Now, those short-term GRATs have been the darling of the estate planning bar, but they may be outlawed because the proposals which have been made under Obama and then Bernie Sanders say that you're going to have a higher hurdle. Number one, you have to have a minimum 10-year term, so you're going to have some estate tax inclusion if you die, not within 2 years, but 10 years, which you can avoid in large measure by using rolling GRATs. But even more troublesome, the gift you make can't be de minimis, it can't be zero. It has to be at least 25% of the value of the property you put in there. And that means you've got to be very, very certain that you're going to be able, over that 10 or longer year period, to have the property grow at such a rate that you're going to get out more than 25%, which is the amount of the gift, taking into account on a present value basis. I think if this happens, you're going to find that GRATs are very rarely used. So maybe, Marty, is now the time to do them?
I think now is a great time to do GRATs. And let me explain some of the considerations in doing a GRAT. So in slide 48, one of the other things that's been proposed in the Sanders and Gomez tax bills is to cap annual exclusion gifts at $20,000 per donor. So even if you have 10 children and grandchildren as beneficiaries of a typical irrevocable life insurance trust, or ILIT, 10 times the $15,000 annual gift is $150 grand a year, which would support a pretty robust insurance plan. They're going to cap that at 20 grand a year. So now may be an opportune time for a unique application of GRATs. Create a GRAT today. It's almost assuredly going to exceed the 7520 rate because it's so low under current law, and have that GRAT flow into or pay into as the remainder an irrevocable life insurance trust. If the insurance trust is not GST exempt, The GRAT's not GST exempt. It's a wonderful way to leverage additional asset value into an ILIT, which may be critical because, as Jonathan just explained, GRATs may not be viable if the law changes, and the annual gifts that have been used to fund insurance may not be viable either. Now, for clients that haven't used up their exemption, just an outright gift to an ILIT may be fine to use it up. For those that have used up much of their exemption or need the exemption for more robust or significant planning, a GRAT to fund an ILIT could be a very, very astute planning tool now. But let's talk a little about the structure of GRATs, because the world has changed. As Jonathan very correctly said, GRATs traditionally have been applied in a 2-year rolling or cascading GRAT structure. And the power of the GRAT was heads, taxpayer wins, tails, taxpayer doesn't lose. So I could put unlimited amounts into a GRAT for a client, structure the GRAT so it used, I always like to have a couple $100 of exemption used just so I have a number to report on a gift tax return. Some are comfortable doing a zeroed out GRAT. Regardless, if the assets grow in value beyond the 75/20 rate, I've sliced off that upside volatility and moved those assets basically gift tax free, ignoring the minor use of exemption, out of the client's estate. So we could do GRAT after GRAT after GRAT, and over time, it's almost like you can't lose because there's no downside of any substance. And if you win, it could be a big win. What would also happen is you could structure GRATs to be very granular. So ideally, you don't put a diversified portfolio in the GRAT. You'd put an asset class in a GRAT, tech stock, international stocks. Bond, not bonds, but a segment of the market, because the whole idea of diversifying the portfolio is that the winners offset the losers, which is not what you want in a GRAT strategy. With a client with enough money, you could actually put a separate stock in each GRAT, because the more granular you get, the less there's a chance of offsetting winners and losers, and you're just slicing off upside volatility. But if GRATs are basically eliminated, as Jonathan indicated, is in the Sanders and Gomez tax proposal, and it was in the proposals in the Obama Green Book as well, we may not be able to roll or cascade our GRATs after this year. So perhaps what should be done to preserve the GRAT benefits, again, considering the very low interest rates right now and depressed asset values, is to do a tier of GRATs, 4, 6, 8, or 10 years. So if you create a tier of GRATs, that may try to minimize the mortality risk. It may try to minimize the time period you have to have assets in the GRAT, because if there's a bump in value, you want to lock that in, which is why the shortest term 2-year GRATs have been favored. But now, if you have longer term GRATs, what you need to do is reevaluate the concept of GRAT immunization. So if I had a 2-year GRAT and I had bought Zoom stock a year ago and it went through the roof, I would swap out or buy out the Zoom stock and put cash into the GRAT. I have 1 year left on my 2-year GRAT. I'd leave cash sitting in the GRAT. I've locked in this immense value of the increase in the Zoom stock. And if Zoom drops, maybe it did because of some of the security issues that they identified, I've locked that gain in my GRAT. I don't have to worry about a subsequent decline in that stock price. That's how we immunize GRATs traditionally. But that doesn't work if you have a 10-year GRAT. Because if I put in a Zoom stock or a tech stock basket into a GRAT and it bumps in value by year 3, I'm not going to take it out for cash and then leave cash sitting for 7 long years in a GRAT. No client would tolerate that level of non-return. So what you may have to do is use hedging strategies or a conservative diversified portfolio, more sophisticated investment techniques that you coordinate with the client's wealth advisor so that you get some tolerable return inside the GRAT, but yet still serve to minimize the risk. So if we use longer term GRATs, we have to deal with mortality issues. In some cases, life insurance is an easy answer to that. And we also have to deal with immunization. Jonathan, I think we should go on because you have a couple of structures that could offer some interesting options to GRAT that would address some of these challenges. But let's just do one more thing before we go. There's another option for a GRAT before we go on to some of Jonathan's interesting alternatives. And I think Attorney Berry created the idea called a 99-year GRAT, very long-term GRAT. This is not a GRAT in the traditional sense that is trying to lop off upside volatility above the 75-20 rate. Rather, this is a pure unadulterated interest play. So right now, with interest rates at absolute historic lows, if you set up a GRAT for 99 years, normally if a client dies during the GRAT term, some practitioners assume that the assets in the GRAT are back in the estate, and that's not technically how it is calculated. If your client dies during the GRAT term, you have to calculate what portion of the GRAT assets are included in the estate. And the way the regs provide for this is you take the annuity payment the client was entitled to, divide it by the 75-20 rate at the date of death, and that's the proportion of GRAT assets to be included in the client's estate. So if interest rates stay level, the whole GRAT is included in the estate. However, if interest rates are 4 times what they are today, and given how low they are today, that's not a stretch and the client dies, the bulk of the assets in the GRAT will not have to be re-included in the client's estate. So with interest rates at historic low, with GRATs potentially on the chopping block, using a 99-year GRAT is not only an interesting interest play, but this could be a last interesting Hail Mary before the law changes. So if it looks like the laws may change and GRATs may go the way of the dodo bird, perhaps a last shot for clients that have already done all the other planning and used all their exemptions is a pretty much zeroed out 99-year GRAT is an interest play to shift asset values. And the slides on 50 and 51 explain that. Jonathan, you have some interesting alternatives that you should explain to the audience, starting on slide 53 with a splat. Jonathan?
Marty?
There he is.
Okay. And these, a GRAT, you create the trust and worry about it your estate. And you also, a GRAT really can't be used for a client with short life expectancy. But the rules under 2702 apply not just if you create a trust with a remainder to your family, but it also covers joint purchases, where you go out and buy, say, interest in an asset, and your family or a family member or trust for family member buys a remainder. But the exception we have for annuities applies not just to trusts, hence a GRAT, but also a split purchase where the senior family member acquires an annuity interest and younger family members or a trust for their benefit go ahead and acquire the remainder interest. And one of the reasons that this is good is with a GRAT, you can't leverage GST exemption. You're always going to have some estate tax inclusion, and that means it's not going to be very good for people with a short life expectancy. But if you do this split purchase of an annuity, and you'll do this through a trust, and there's a very good form that's available in that BNA tax management portfolio that I mentioned previously, you can go ahead and have it where your client buys the right to an annuity, and you don't have to worry about gifts because you're going to follow the exact rules under section 7520, which tells us how to value annuities, just like we do with a GRAT. So you'll have no gift at all, and the buyer of the remainder can be a GST exempt trust, so you can leverage your GST exemption. In addition, as long as the client's death is not imminent, because the regs under 2702 say you can't use normal life expectancy if the client's death is imminent, which means there's under a 50% chance of survival for at least 1 year, you can go ahead and use it when you do a splat. So you have a client who may be old, may have a real problem, or maybe young but has a serious health problem. You can go ahead and do a splat, where the client acquires the right to the annuity for life, and when the client dies, nothing will be includable in her estate, provided her death was not imminent at the time that you set up this arrangement. So that's something to consider. And in fact, you don't have to make it for life. You could make it for a term of years. So if you've got a really senior citizen, maybe you want to do it not for that. But you can make the annuity any size you want. You cannot exactly zero it out, because if you do it for life, that's just the way the actuarial rules work. But you can make the value of the remainder very, very small. And that way you can get a tremendous amount of property out of the estate, especially for a client with a short life expectancy.
So let's go on to another technique, and this is one that you, Jonathan, with Abby O'Connor and I think Mitchell Gans just wrote an article about, and it's a creative and interesting approach to resolve or avoid the issues that some perceive with domestic asset protection trusts. So, Jonathan, if I'm going to be a beneficiary of a self-settled trust, even though many think that the DAP should work, even if you don't live in a DAP jurisdiction, but absolutely if you do, what's another approach that we could use to make me have access to a trust that I've created without the DAP risk?
Well, the DAP risk exists if it is a so-called self-settled trust. And when you take a look at the restatement of trust, when you take a look at the Uniform Trust Code, everything, a self-settled trust is one that you have created for yourself. And to the extent that the trustee may make discretionary distributions to the grantor, unless you're in a DAP jurisdiction and it's respected, you're going to have creditor access to those assets. So why don't we avoid having a self-settled trust? Certainly, unless I'm making a fraudulent transfer, I can create a trust for my wife and kids. No problem. It's not self-settled. I'm not a beneficiary, so it's not going to be in the pool of assets that my creditors can attach, or in the pool of assets that will be includable in my estate. So I create a trust for my spouse, again, defined the way you want it, either the person to whom I married at the time in question, or Mary Jane, or whatever the wife's name is at that particular time. With remainder, and for my kids. But I'm not a beneficiary. In fact, the trust is limited from ever making a discretionary distribution to me. Nonetheless, someone in a non-fiduciary capacity who is not a beneficiary has a special lifetime power of appointment to be able to appoint assets to a class that would include me, like the descendants of my mother or the descendants of my grandmother. So as a consequence, it is not a self-settled trust. And we're even going to say you can't exercise this power in order to add me as a beneficiary of the trust, but you can appoint assets directly to any member of the class. Now, everybody on this phone has either seen trusts or done trusts where someone has a special power of appointment, and you haven't prohibited that power from being exercised in favor of the grantor. And as a consequence, you've never thought whether you're even in California or New York or Florida, that all of a sudden this is a self-settled trust and creditors can get it. It's not a self-settled trust because the grantor is not a beneficiary. And you don't want to have the power to add the grantor back in as a beneficiary because of that Iannotti case I mentioned a little while ago when we were talking about hybrid DATs. But this one that Abby and Mitchell and I came up with, it's a trust for your family, but someone or a number of people in a non-fiduciary capacity have a special power of appointment, and they're not beneficiaries. When you have a special power of appointment and you're not a beneficiary, that's called a collateral power of appointment. And that's common throughout common law, and you can read all about it in the Restatement of Trust. So it's not an odd thing. That does happen, and you just do it that way. So someone you trust or a group of people you trust, maybe your three oldest first cousins living at any time that are competent, can go ahead and exercise the power. Now, you may also want to say, but you've got to get the permission of someone whom the grantor trusts, such as her lawyer. So I give this power to my three oldest adult and competent cousins who can appoint it to a class consisting of descendants of my mother, which would obviously exclude them because they're not going to be descendants of my mother. And yet we don't have to worry because they need the consent of my lawyer or they need the consent of another person whom I trust. But if I fall on hard times, the power could be exercised for my benefit. Now, you might say, but gee, you're making it so it has to go outright. Well, if I need money, I'm probably going to need it outright, or it can be applied for my benefit outright rather than doing it in trust. And this is, I think, a superior form of domestic asset protection trust because the trust is not self-settled. And you can read all about it in the February 2019 issue of Estate Planning Magazine. You'll see an article in there on SPATs by Abby and Mitchell and me. Back to you, Marty.
So, Teresa, if a practitioner on the call has never drafted a SPAT, they're intrigued by the idea, they think that it's appealing to avoid what they may perceive as a risk of a self-settled trust, is there a way they can draft such a document?
Absolutely. And the Special Power of Appointment Trust is a document that we're adding to Wealth Transfer Planning, one of our interactive legal systems. And as Jonathan and you were both mentioning, it's really kind of an irrevocable trust for the family, but you have this extra feature, this special power. And so we have those options on the screen, an example of which you can see here, where you can name an individual to hold that power, or it can be a group of people holding the power. Down below, the portion that's highlighted is where we say who the permissible appointees are, because again, we want it to be a class that includes the grantor, not just the grantor. And so you could custom draft the class, or we have some standard options that would include the grantor, such as descendants of the grantor's parents or grandparents. And then the next screens, there's two screens that follow. They both show additional options on this same topic. Here we've checked the box for delaying the time until the power can be exercised. And again, we have those same time periods that we have in the Domestic Asset Protection Trust, the 10-year period, the 1-year period, or custom. And you can also see I've highlighted the drafting tip there on the screen. So for somebody who's new to this, there's commentary as you go, and that I think can be very helpful. The next screen also has another option for the power of appointment, where we're talking about what Jonathan mentioned, requiring consent. Let's have somebody, whether it's an adverse party or maybe it's like the client's lawyer, require consent to exercising this power, so it's not just exercised without kind of a check on that. And again, a drafting tip that talks about why that might be advisable. And I think there's one more screen with some options. Yeah, this is another thing. I'm not sure if I heard Jonathan mention it, but you could set up this trust to be a completed gift or an incomplete gift, and why might you want to make it an incomplete gift? There's a discussion there on the right-hand side again on the drafting tip as far as why you might want to make it one or the other. In most cases, I think these are set up as completed gifts. We want it out of the estate and so on, but there might be a reason to do it the other way. And rather than having to redraft, you just check a box and you have the other option. Oh, one more screen. Yep, this is, again, who are the beneficiaries while the grantor is alive. You always have the option of just naming the spouse, or having the kids added in, or adding in all the spouses of the kids as well, and even custom drafting a class of beneficiaries if you have a situation where, say, you have a couple who doesn't have children and they want to include nieces and nephews or other family members as beneficiaries.
By the way, let me add that if you go back, Marty, go back that prior screen, it talks about the grantor's wife. That's because the grantor in this case happened to be a man.
Right.
The document system will automatically say the grantor's husband if the wife is doing it, and we even have an option where you just use the more neutral term of spouse throughout your drafting. So don't think we're being misogynistic here. It's whatever you choose, you can use.
Right. Oh, and it also, it doesn't mean that the grantor was a man, Jonathan. You can have same-sex marriages and have a wife for both parties. So it works both ways. Always work.
You're absolutely correct, Teresa.
You can use the gender-specific terms if you want to in any situation, or if you'd rather be gender-neutral, you can just say spouse.
Apropos to that comment, I've been working with Vanessa Kanaga and Jonathan, and Vanessa, I and Steve Kriz and Melissa Sayoun have just have an article coming out in Trust in the States on some creative ways to draft for the LGBT community. And I think Interactive is certainly committed to making their documents not only gender neutral, but to at some point add some more creative planning that can help that community. On slide 64 is the actual language to create the SPAT out of the interactive system. So if you don't use a document generation software program, and you should, I think, here's the actual language on slide 64 and 65. So we've given you the actual language. Jonathan, I think we should have one more technique and then we can wrap up. So I'm gonna let you explain your split purchase trust on slide 67.
Yeah, well, this goes back to section 2702, and as I said, annuity trust like a GRAT or a split purchase annuity trust fall under a special rule. But 2702 has an actual exception to its operation for homes. And all of you are familiar with QPERTs, Qualified Personal Residence Trust, QPERTs, which aren't used so much today because interest rates are low, and in determining the value of what the grantor retains, you use normal income generation, which today would be 1.2%. But there's a better way to go forward because you can't use a QPERT for someone with a short life expectancy. And I've had some QPERTs work out just fine, and I've had some fail because the client died before the end of the retained term. Now, there may be some things you can do to avoid that if you know the client's going to die. But you can't do any GST exemption leverage. You're going to have full estate tax inclusion, not partial, as we talked about, for example, with a GRAT. And once the term runs out, the client's going to have to either move out or pay rent. And sometimes people don't really think about it. And even if you told the client, you know, when this term ends, you're going to have to pay rent. And that's really good from an estate tax perspective because, you know, you can make it to a grantor trust. There won't be any income tax and you're depleting your estate. I've known some of my clients, even though we told them at the beginning that would happen, who were very unhappy that they now have to pay rent. So better than that, you do a split purchase of a residence. And that falls under the exception, just like a QPERT does. But now you can have the client buy a life estate, and if the client's married, her spouse can buy a secondary life estate, and a GST-exempt trust can buy the remainder. It's a really super deal there. If you're buying it from a third party, you're not going to have to worry about making any gift whatsoever. And you can use it even if their life expectancies are short. I came up for this for clients of mine who were moving from New York to Florida. They were buying a very expensive new home. They both had cancer, which unfortunately did kill them 3 and 4 years out. But at the time that we did this split purchase of a new residence, where they bought life estates, husband bought a life estate, wife acquired a secondary life estate, and a GST-exempt trust bought the remainder. Both estates were audited by the IRS, and no one contended there was inclusion. Now, a lot of my colleagues originally thought, well, this will never work, but it does work. It's a great idea, and it's something I would suggest you consider in lieu of a QPERT.
So we're going to just wrap up. Oh, no, we're not. Teresa.
Yeah, this is just one more thing I added in because I wanted to kind of put this in as a wrap up after Jonathan talked about the SPLAT and the split purchase trust, and we mentioned GRATs earlier. We're not showing the options for drafting, but they're all here in the menu. So if you wanted to draft one of these unique split purchase arrangements under section 2702, a SPLAT in lieu of a GRAT or a split purchase trust in lieu of a QPERT, because you have the added benefits of doing it as a split purchase, they're available right there in the system, and so you don't have to wonder, where do I get that form? It's in your drafting system. And so I thought that was kind of a good way to wrap up what we've been talking about as far as the breadth of documents available.
Thank you, Teresa. So let me just wrap up because we're well over our 1 hour, but I think it's been a very valuable, informative program. We're living in a very unique environment. We all, not just our clients, we all remain fearful of the health issues of coronavirus at the time that we're doing this program. We're all concerned about the economic impact of what coronavirus has done to the economy, and how and when and in what manner the economy will restart, and what it will do to business values in the market. But apart from those issues, it is a uniquely valuable opportunity for clients of even moderate wealth to plan, because if Jonathan and I are right and the exemption amounts are lowered significantly in the near term, and rates and are raised, and other estate planning restrictions are put in place, which just seems inevitable. I mean, we could be wrong. It's hard to predict anything. But it just seems inevitable in order to help finance the massive bailouts that the government has done and may do yet more of as we're speaking. We've given you 7 options to do planning. Common to most of these options are ways for the clients to have significant access or benefit from the assets that are being removed from their estate. We've tried to talk to you not just about the planning, but some practical drafting and implementation techniques. And what we've also done is, for those of you who are still drafting using firm forms, we've tried to illustrate the power using Interactive Legal as an example of document generation software generally. And hopefully what we've done by giving you a myriad of different options for each of these techniques is illustrate how powerful a document generation software system will be for your practice. And if there's a deluge of clients coming to plan as we get later in the year and the current fears hopefully subside, we will need the efficiency of document generation in order to really tailor planning and documents to each client's unique circumstance, help them both use exemption, remove assets from their estate, most important, preserve access to assets. Jonathan, any final comments that you want to make to wrap up?
No, Marty, I hope that people did find this informative, and keep in mind that you're going to have to emphasize why this is in the client's best interest. Just saying that this is great for, future descendants, I don't think it's going to cut it today. I think you're going to have to be, very, very cautious in approaching these things for them. But again, preserving their wealth for themselves as well as for future generations is something that I think clients will want to hear about. But it all depends on the delivery.
Thank you for joining us. And for those that were on the aborted call earlier this week, we apologize. It was just internet issues beyond our control. And hopefully by making this separate recording available to you, we'll have made up for that issue. And I assure all of you that we're investigating other options to try to deal with the struggles and issues and challenges of working remotely. And again, it's not something within our control. It's simply been internet issues, and we're going to try to solve the problem with some creative solutions. Thank you for joining us. And on slide 74 are our email addresses. Unfortunately, I didn't list Teresa's email address, but if you have a question about Interactive Legal, Vanessa Canega's email address is there. So please don't hesitate to email any of us. And if you want any of the articles that Jonathan and I mentioned throughout the program, simply email me and I'll be happy to send them to you. Thank you and stay safe.